to Money Matters. I'm Tom Spottiswood of River Bay Investment Group, Wells Fargo Advisors Financial Network, based in Gaithersburg, Maryland. And today, we have a great show for you. It's Dan Ruttenberg. He's a partner at SmolenPlevy in Vienna, Virginia. And we're going to talk about updating beneficiary designations. It's a very important topic that a lot of people tend to ignore. So thanks a lot for coming on the show.
Thanks for having me.
We really appreciate it, and we had some nice chatting before the show. But talk to us a little bit about what you do. You do estate planning and administration with SmolenPlevy?
I do estate planning for individuals. If you have a closely held business, which doesn't mean a small business, it means it only has a few business owners. We do the succession planning for that, how it gets to the next generation, or are you going to sell it, or what is your exit strategy. And then that leads to general corporate law, but basically it's a lot of tax work. When you're doing estate planning,
Sure.
You're planning for taxes. Succession planning, you don't want to pay capital gains when you sell or things like that.
All the little nuances
Sure.
I'm not paying. Okay, so 2013 Smart CEO magazine, you were a power player. Northern Virginia magazine named you a top lawyer, and tell us a little bit about your background.
Well, I'm very local to the D.C. area. I was born in D.C., spent my whole life here, went to University of Maryland for my undergrad, went to George Mason for my JD, went to Georgetown for my LLM, so I'm very local, and out of law school I started 17 years ago with SmolenPlevy.
That's great. I mean, it's funny because here in D.C. area you see some very local people, and then you see people from all over the planet, so it's great to meet locals once in a while too. Tell us about this case that you worked on. That I think that's and to me when we were discussing the show, I thought it was very relevant and very critical. You're talking about updating beneficiary designations, and I think that applies to everything: your annuities, insurance, IRAs, 401k plans. Why don't you talk a little bit about this case that you brought before the Supreme Court? I think that's a great story.
Okay, well, let me just give a little bit of the background of the case. So just the basic facts. And the case is Hillman v. Maretta. And Warren Hillman was a federal employee. And like most federal employees, they get Federal Employees Group Life Insurance, referred to as FEGLIA. People call it FEGLIA. And at the time, he named his wife as his beneficiary. But then he divorced her, and he remarried, and he died unexpectedly. And he never changed his beneficiary designation. So I'm just
curious. Was it a long time after he got married or divorced, or that he didn't?
Several years.
Several years. Okay.
Yeah.
So he had plenty of opportunities to update the beneficiary, and he never did it.
Yes.
Which is pretty typical, wouldn't you say? Or
happens all the time. I see it all the time I mean, even if you have a will, most people don't even have wills these days. So to actually go through and update your beneficiary designations, normally when people finish a divorce, they go through so much stress with just the divorce. The last thing they want to do is when it's all done, oh yeah, let me go through and update my estate plan. They're not thinking of that. They're just trying to put it behind them. I'll deal with it later, and then they just forget about it.
Right.
So it's very, very common to do that.
I'm just curious. We're recommended about once a year when we do the financial planning as an advisor to talk to our clients and say, look, you should update your beneficiary designations. Is that an accountant's job, or the attorney's job, or the advisor's job, or everyone should be on top of this?
I'd say it's more everyone. I mean, accountants, financial advisors, attorneys, estate planning attorneys often are doing a lot of overlap in sort of what they're looking at. I don't think updating a beneficiary designation is the practice of law, but when you're doing your estate plan, it's a very important piece. To give like a worst case example, a lot of people in their wills will have something that says, I have a trust for my child until they reach a certain age, maybe 35. But then they name their child as the beneficiary on a life insurance policy, which is often their largest asset.
Right.
And the beneficiary designation controls and bypasses your will, and that kid gets at age 18, which can be incredibly harmful to a child.
Right.
So it is very, very important that when you do an estate plan, you go through every asset title, every beneficiary designation, and make sure it dovetails to the plan that you've established.
Well, going back to worst case scenarios, let's go back to your story. I'm sorry to interrupt.
Oh, okay, yeah. So that's all right.
I got you off track. Yeah, that was my fault.
Story. So Warren Hillman, okay, so he's this federal employee, and he gets divorced, and he dies. And under federal law, they want to pay the beneficiary designation. But many states have enacted laws to protect widows and children so that the money and the benefit of these dollars go to the family instead of going to the ex-spouse. And the question that this case addressed was, can a state do that? Or does the federal law preempt the state law? And that was the issue of the case. Do you want the outcome of that case, or we can get to it?
No, okay. Or talk about the details, how you got there. I think hearing the story is very interesting.
Okay. So how this got to me, I'm not a litigator. And in fact, the case, it had been about 7 years since I had litigated, and the only case I litigated before that, or not the only case, but the last case, I represented my sister against her landlord.
Okay.
That's like the big types of cases I was doing.
Okay.
So, and I thought this was a similar case. I thought this was a small case because there's a Virginia statute right on point which says that the widow can sue the ex-wife for the money. I mean, it's clear cut, no issues. So I thought, you know what? Kind of got the bug a little bit to litigate, could do it as a little side project, talk to my partners, make sure they were okay with me picking up a litigation when
Sure.
I'm not a litigator.
Sure.
Yeah, sure, no problem. And so I take this case and I sue in Fairfax Circuit Court, and thinking it was a slam dunk. And that couldn't have been.
Little did you know.
Little did I know what I was getting myself into. I mean, I went down a journey of things that I needed to learn. Had I known, I never would have done it. But once you're in a case, you're in a case. You're not going to drop out of that.
Were you talking about a large sum of money, or?
No. It was like a $150,000 life insurance policy, which to some people is a lot of money.
Right,
but
right.
in the overall scheme of things and for the amount of effort that went into this, no, not at all. But the case I really took, I mean, I had a client and she needed help. And I really felt she should get the money and not the ex-wife.
That was what the husband wanted. That's what the husband assumed was going to happen.
That's what I believe the husband wanted.
So that's common sense, and the law on the book said that she should get that also.
Yeah. And I thought she had an absolute right to it. Now, she clearly didn't have an absolute right to it, because what happened was the opposing side said, no, we don't want to, this is a federal case, we want to have it heard in federal court as opposed to the state court, which, so they filed, it's called removal. They removed the case to the federal courts and put it in what's known as a rocket docket in Alexandria, and said, no, there's federal preemption. I didn't see federal preemption coming at all. So normally you have 30 days to respond in something like this. But because they did it in the rocket docket, I had 11 days to respond.
Correct, okay.
And in order to file in federal court, you have to electronically file. In order to electronically file, you have to pass a test. I had to read this much stuff just to learn to do electronic filing, so I could then go and file my response within the 11 days. And then while I'm starting to research federal preemption and learn the law, what I learn is most of the time the state courts will rule for the states and against federal preemption, and the federal courts will rule for federal preemptions, hence why I wanted it there. So I wanted to get it back to the state courts. So then I have to learn the law of federal jurisdiction, which I didn't really know anything about. I remember a little from law school, but you don't really know that stuff, so I had to research that, as well as the law of federal preemption, all within this 11 days. So here I get to win my first battle. I win on the federal jurisdiction thing, get it kicked back to the state court. Well, then the next thing the guy does, he says, well, I don't want to have it heard in Fairfax County. I want to have it heard in Albemarle County. I don't even think I'm pronouncing it right, but it's way far away. And I certainly didn't want to try a case down there, and I didn't know any of the judges down there. At least I knew some of the judges in Fairfax County. Sure. So I have to learn the law. That's called venue. Which county is called venue? I had to learn the law of venue. So again, I'm able to win on that battle. So then the next battle was the actual court case in Fairfax, and we went at it, and it was several hours of arguing back and forth, and the judge, he was taking it so seriously. Normally in court they have limited time, and we ran up against his next, what they call docket, but his next group of cases. He said, you know what, I'm going to go through those quickly. You guys come back. I want to make sure this is properly done. And then he, at the end of it, he said, I'm not going to rule now. I'm going to think about this for a month. I'm going to write an opinion. They rarely do that. And 2 months later, he comes out with his opinion. I win. I think I'm doing fantastic. All right,
well, why don't you hold right there? We'll be right back after this break. Please stay tuned. Welcome back to Money Matters and our discussion with Dan Ruttenberg of SmolenPlevy about updating your beneficiary designations. Okay, good. So this is a great story so far. I like the way it's going, but I don't think it ends the way you expect it to. But please go ahead.
Okay, so continuing on the journey to the Supreme Court, the next step, I thought I won. And then you have to learn, collections and all that stuff. That's a whole other issue. But they appealed it to the Virginia Supreme Court. Now, I figured that they wouldn't take the appeal because they only take maybe 5-7% of the cases that go up there. And the way that works is they file a brief saying, we want you to appeal it. I object, and I tell them why they shouldn't accept the appeal. And then they get to go down and argue and say why they should take it. Well, the Virginia Supreme Court said, don't bother coming down. We're going to take it, which was a really bad sign for me at that point. And I actually got kind of depressed about it. And I went and I talked to someone who did a lot of appellate work, and he gave me some sage advice. He's actually the newest circuit court judge in Fairfax now, but at the time he was an attorney. He said, look, Dan, if you got to die a glorious death. And I said, yeah, you're right. You know what? I'm just going to you just do the best job you can. You go down swinging.
Right.
So they took the appeal. They hammered me on it. It was actually a split decision. And they said, we're going to overrule the circuit court. And so I said, you know what? I'm not done fighting. So I'm going to take it to the United States Supreme Court. Now, they never take a case. They get 10,000 appeals a year, and they take maybe 75. So never do they take a case, and they certainly don't take, estate planning cases. It's very unusual. But this one was ready for it. So I knew we had a chance, and I appealed it up there, and lo and behold, they took the case.
I always thought that the Supreme Court, well, at least this Supreme Court, I always thought they were kind of friendly to states' rights. Is this a states' rights compared to? What's the crux? What's the question here? Because the state had said that yes, she can sue, she can get the money back, but it was overruled, and I guess you're going to go into that.
I don't want to get too technical,
okay.
but where this came from is this was a question of congressional intent. What did Congress intend? Because if Congress wants to, they can say what we say goes. Or Congress could say, we're sort of setting up this rule, but we're allowing the states to affect our laws. And so it's really a question of what did Congress intend? And there's a similar life insurance statute for servicemen, for our military, which had a provision in it that was identical to the one in the federal employees group benefit, which was what they call the order of precedence. Pay the beneficiary designation, and if not, pay the widow, and if there's none, pay the children, etc. And it was verbatim. So these two provisions were modeled after each other. And in their earlier case dealing with servicemen's group life, they said that provision preempted all state laws. And I was arguing why the exact same provision didn't for federal employees group life. And apparently I couldn't get over that hump, although I still think that was the intent. And if it's not, I think Congress should change the law and make it that way, because it's a better law to allow states to affect this stuff. And here's why. This is where it starts affecting people at home. Okay? So right now, let me give away the ending of the case. The Supreme Court determined that the federal law preempts the state law. Okay, so states cannot impact the benefits for federal employees group life.
Amazing. Okay.
Within limits. So what does that mean? What it means certainly for estate planning is it means that these laws that are designed to protect the widows and the children and those sorts of things they still apply when it comes to a private policy. If you buy Lincoln Financial life insurance, that will still control, but not for federal employees group life. For federal employees group life, that's like magic money, and doesn't matter what states say, it's going to go where the statute says it's going to go.
Well, obviously that's very interesting to our audience, because a lot of them are going to be government employees in the D.C. area. So this would have a big impact on how they should be considering what they're doing for their insurance and everything else.
Yes. Well, and federal employees group life insurance is by far the largest life insurance plan in the world, but it goes beyond just estate planning.
That's great.
Well, who can't imagine who would have a bigger plan than the federal government's plan? I mean, IBM's not bigger. So, but beyond that, imagine the scenario now of a divorce. Every state has divorce decrees. People get divorced, and there's divorce orders which say, maybe you need to maintain the insurance for the benefit of the children. Well, there is an exception that they put into the statute. Says, okay, fine, you can file the divorce decree with Office of Personnel Management, OPM, and have it impacted. But Who thinks of that? I mean, a typical person getting divorced isn't going to think after they get their divorce, boy, I have to go now file my divorce decree with OPM to make sure that my husband or wife, whoever, my ex-spouse, doesn't change their beneficiary designation.
Honestly, I think probably a lot of good attorneys would have that on a checklist. Hey, you need to get this done, but they have so much going on, they're not going to look at it.
Well, and I'd like to think that's the case too. I mean, all attorneys are great and perfect out there, and but I think there's an incredible risk of it, quite frankly, and it scares me. It's discouraging because imagine the scenario of where this is for the benefit of the children. Not even for the ex-spouse who says, okay, fine, I get that in case. It's for the benefit of the children. Well, if mom doesn't pay attention and doesn't file it, the children lose out. They can't file it themselves. They can't say, hey, I was relying on mom. So what this means is the way the law is set up is you really need to pay attention to such things. You really need to pay attention to not just how your beneficiary designation reads, but if you're trying to force an ex-spouse to maintain somebody as a beneficiary, that has to be filed. And if you live in a community property state, not that we are, but those laws don't apply.
What do you see? We're talking about this with the FEGLIA, the Federal Employee Insurance. What do you see with IRAs or 401ks or annuities? Does this pop up often, or?
Well, it comes up even. I mean, those are obviously more common than Federal Employees Group Life. Not everyone, but most people have retirement accounts, and whether they know it or not, it's governed under this act known as ERISA. And the courts have absolutely said that you have to pay the beneficiary. Okay, they've said that because they don't want the administrators to try to figure out what the laws are of the different states and that stuff. They want sort of a plan, document, rule. All they have to do is file the plan. The question that does remain a little bit in that world as opposed to Federal Employees Group Life Insurance is if it gets paid out and it's not done in accordance with that court order or not done in accordance with the statute, can the widow or the children, do they have a claim against the beneficiary after it's been paid out? And that question is still up in the air a little bit, although most of the courts have determined, not all of them, but most of them have determined that yes, you can. It's only with Federal Employees Group Life Insurance that they have said no, you can't. So, that being said, you still don't want to deal with that. You don't want to deal with a lawsuit after someone dies trying to get the right beneficiary designation put in place. I mean, you really need to make sure that you go through. People think, hey, I have a will, I've done my estate plan. And that's really not correct. There's a lot of components to estate planning, and you need to make sure that those things are updated and accurate.
I'm not an attorney, I'm an advisor, but I know we have something called transfer on death. Mm-hmm. So with transfer on death, we tell people this supersedes whatever you've done with your will or estate planning, the way the beneficiaries are set up.
That's right.
And I think with IRAs, it's the same thing. That's correct, right? Whoever the beneficiaries, that supersedes. Yeah. Whoever's written is supersedes.
People don't realize this. Basically, when someone dies, their assets are categorized one of two ways. You have your probate assets and your non-probate assets. And your non-probate assets, they're the ones with instructions built into them. So things with beneficiary designations, things with titled jointly with rights of survivorship or as tenants by the entirety, those things go to the person who you have it titled jointly with or to your beneficiary designation. Doesn't matter what your will says. Your will only governs assets that are your probate assets that don't have the instructions built into them.
Like the house or the car or
your car, your financial accounts, your bank accounts, all that stuff, but the things titled solely in your names that don't have the instructions, that's what the will grabs hold of. But but these other things, beneficiary designations, titling, that all supersedes it. So people often will bypass their estate plan inadvertently. So having a will does you no good if you don't have your assets titled right.
I had a client, they changed their 401k plan because they didn't want to leave it to the ex-spouse. All right, well, why don't you hold right there? We will be right back after this public service announcement. Please stay tuned. Welcome back to Money Matters and our discussion with Dan Ruttenberg of SmolenPlevy about updating your beneficiary designations and estate planning. So, very interesting case going to the Supreme Court, and we talked a little bit about the beneficiary designations, how important it is to make sure that's squared away, And maybe people should just do it annually. They should meet with their advisors annually, or maybe when they're doing their tax returns just to check that stuff. Just as a good habit.
What I do with my clients, generally speaking, first you got to do the estate plan. So if you haven't done one, get in and do an estate plan.
Yeah.
But once it's done, I normally put people on a 3-year review. Some people, some attorneys do it annually. If there's a reason to do it sooner, there's a change in your life, you get divorced, you have a new child, you get married,
right.
They'll often come to me sooner. Or if there's a change in the laws which necessitates a review, like Maryland had a significant change, recently had another significant change, but Maryland might require a review of someone's estate plan. I will reach out to them and say, hey, let's do a review now sooner. But other than that, I typically put people on a 3-year review, and at those reviews you're going to go over, does it still leave the assets where you want them to? Are the people you've designated still appropriate?
Do you still like your spouse?
Do you still like your spouse?
Do you still like your business partner?
Right. And what's most important, are your assets still titled the same, the way they should be? Because your assets change. People buy new cars, they move, they change accounts. You wouldn't believe how often that happens over a few years, and you got to go and get it all back to be titled right again.
It's so funny you said that. We just had an account, and I got a call from MFS today, and this happened this morning, and this was an account from 15 years ago, and now they're looking for me to set it up properly, and I'm like, this stuff follows you around. I mean, things change, but on the other hand, you got your trail too, so you got to keep tight on that.
Absolutely.
Where do people get caught on estate plans? Where do you see the biggest mistakes that happen that people should be avoiding?
Well, the biggest mistake is not doing it. That's the number one thing. Number two, beyond that.
Can I say something?
Sure.
People talk about wills and estate planning. Estate planning sounds like, oh, I'm hyper wealthy, and that's only for super rich people. That's not something that affects me. How do you respond to that?
That's not the case at all, actually. First of all, a lot of people think of estate planning as a will, or a trust, and estate planning isn't a product. It really is a process, which is why you need to keep it updated. It's not like you do it once and you're done. But that's staying updated. I'm sorry, I've totally lost my train of thought. What was the rest of your question?
No, the question was like people are saying with estate planning, I'm super wealthy and
yeah. So, but for someone who has a lot of money, you're right, your family's going to have a lot more to deal with. You're going to have maybe a lot of estate taxes to pay, but your family still gets a whole lot. People that are not wealthy, those are the ones that really need every dollar to either be there for their care or be there for their family. And there's a lot of traps for the unwary and a lot of unnecessary administration or assets going where they shouldn't go. And you really, people that don't have money.
For example, what are the traps? Where does the money go that it shouldn't go?
Well, here's a scenario. Let's say you have everything in your name, and you become disabled.
Yes.
Okay? And when I say disabled, I don't mean you're in a wheelchair. I mean you're mentally incompetent. You had a stroke. You have Alzheimer's. You're not legally competent to sign your name. And now you have this scenario where your spouse might want to access the equity in the house, might want to sell the house, move, because you've got to be moved to a facility. They can't. Why can't they sell that house? They can't sell the house because you're not legally competent to sign your name anymore. And you've got to sign your name to the deed. So if you have no estate planning in place, you're in a lot of trouble. And you have to, in Virginia it's called a conservatorship, and you have to be declared judicially incompetent. It's a place you don't want to be. It's a huge area you don't want to be.
You got to hire a lawyer.
You got to hire lawyers.
Everybody loves doing that.
So you need to have planning in place to deal with those things. And there are things that can be done. And there are different levels of things. Some work better than others, but there are things to be done. People will put someone else on their bank account and say, oh, well, if something happens to me, they can get into the bank account. But now you run into issues. Boy, I put my kids on the bank account, and my kid just got divorced, and now my bank account is part of their divorce proceeding, and they've got to present evidence why it's not their money. You don't want that. Or they get, creditor issues. They hit a school bus load of kids, and now your assets are subject to their creditors.
What about commercials online? They say you could do this estate planning, you could do your wills, you could do everything online. What's your gut on
my gut on that? My visceral reaction? I think they're incredibly dangerous, quite frankly, because what happens is people get a false sense of security. They think they have good estate planning in place because they don't know any better, and they don't have anyone guiding them on this. So they don't go to have it done properly because they think they've had it done. They took the step to do it, but then they haven't necessarily done it properly. And it's, you know, maybe you have the right document, maybe you don't. Some of these concepts are pretty tough. And beyond that, going in and making sure and understanding all the asset titling ramifications and those sorts of things, the odds of someone getting all that done and properly done are fairly remote, yet they're not going to seek the advice.
Sometimes you need a professional, just some situations. If someone wanted to...
It's what I do for a living, but I honestly believe that stuff is dangerous.
Yeah. Well, it's not that you're the smartest guy. I said, look, I'm not the smartest guy in the world, but I've seen this again and again and again. Some of it's stuck in my head, so just leverage my experience. Okay, so how if someone wanted to find out more, where would they go?
More about any of this stuff?
Estate planning or you, or if they want to contact you?
Well, if anyone wants to reach me, I'm with SmolenPlevy. Our law firm is SmolenPlevy.com. Phone number is 703-790-1900. Can email me, dhruttenberg@SmolenPlevy.com. Be happy to talk with anyone.
Thank you very much. We really appreciate you coming on the show. I thought that was great.
Thanks for having me.
It was very interesting, and congratulations, you were on the Supreme Court.
Thank you.
So thank you very much for tuning in. We appreciate all the questions and responses and to the topics and the shows we've been having. If you want to contact us, you can reach us at riverbayinvestmentgroup.wfadv.com. That's our website. And we look forward to seeing you next week. Remember, your money matters.